Yeah. Have you seen my screen?
Yes, teacher.
Okay, just wait a minute. Maybe something wrong with my camera. Why is all black? Okay, so I will fix my camera later. Now, have you seen the screen? So today we study the next chapter, the content of a contract. So yesterday evening I sent you a like some pages relevant to what we're gonna study today. And yeah, as you know, today we'll discuss about in a contract there should be like what should be included in the contract. Now, first of all, we should know the types of the contract. So people may have different ways in order to classify the contract. Now here, I just give you the three ways, three kinds of contracts according to the different criteria. Like the first one, we have unilateral contract and bilateral contract. So it's subject to the parties to the contract. So if that contract is entered into by one party only, it is a unilateral contract. So you may question why the contract has only one party. And I think I have already explained to you before about the parties to the contract, so that you can know the privileges of the contract. In most of the contracts, they are entered into by one party, by two parties or more. But in some kinds of contract, like the contract to give a gift to the any persons who can perform an action, I lost my dog, and if someone can find it, and I will give them some gifts, maybe money or any other kinds of gifts, just to appreciate the action. So in this case, it is a unilateral contract. The contract is entered into by one party only. And bilateral contract, even though they have the word by, it doesn't mean that the contract is entered into by two parties only. So if the contract has more than two parties, we still call it bilateral contract. So this is the way that people classify the contract based on the number of the parties to the contract, right? The second one is oral contract, written contract, or contract by conduct. So can you tell me, based on what criteria, people classify the contract into three different kinds, like this one? Bảo Ly.
Dạ cô.
Um,
Sorry, Lee. So are you answering my questions? Bảo Ly, I can't hear you. Ngọc Mai.
So the oral contract is a kind of contract. It's created in.
Ngọc Mai.
Yes, teacher, I'm speaking. Can you hear me?
Ủa các bạn có đang nói không ạ? Cô đang sợ cái lo của cô có vấn đề. Các bạn nào nói lên cô một cái.
Dạ có mà cô, vừa nãy Ngọc Mai có nói à.
Mai đang nói
Ồ, vậy là Mai lo cô có vấn đề rồi hả? Giờ cô tí nha. Speaker. Rồi các bạn nói lại giùm cô một cái đi.
Yeah.
Mai.
I think.
Hello.
Dạ cô ơi, cô nghe được em không ạ?
Ủa Mai đang nói hả Mai?
Dạ đúng rồi ạ.
Không nghe được gì hết luôn. Các bạn chờ cô tí nha. Trong thời gian chờ cô á, lớp đọc cái phần ở phía sau về nội dung bên trong của cái hợp đồng để một câu hỏi lớp nha. Cô đang mời cô điều chỉnh cái speaker của cô một tí, tại cái máy này là máy mới, chúng ta chưa có cài cái gì đó, cô bị miss cái gì hay không? Okay, I think we must start now. Can you try talking? Now, Kanlim, please, can you hear me?
Yes, Miss.
Okay, so anyway, there's a problem. I cannot hear you. Sorry, Kanlim. Okay. So yeah, contract by contract is one in which the terms of the contract are not stated by the parties. Okay, the contract is entered into by the behavior of the parties. An oral contract is one in which the terms of the contract are spoken by the party. Okay. So my question is, based on what criteria people like classify the contract into the oral, written, and a contract by conduct? So the criteria here is the formality, right? They based on the formality of the contract. So the contract can be under the form of an oral contract, a written contract, or a contract in writing, and a contract by conduct. And based on the nature or based on the content of the contract can be classified as construction contract, commercial contract, or technology transfer contract. So it's subject to the nature, and they just name based on the nature of the transaction. Yeah, so about parts of a contract, so I would like you to look at page 31 and 32, and they give you very detail on the parts of a contract. Here they say they not care about the type or any subject matter of the contract. So the type of the contract consists of the following parts. So this is the very general information about the parts of the contract. And then during this course, I will learn how to draft a contract, how to draft each part of a contract. Then you see the first one is the title, and then the introductory paragraph. This paragraph will introduce the parties, right? Who are the parties to the contract, and the date of the agreement. So we will go into detail later. And the recitals or the statements of the background facts and the definition. And the main content are the substantive provisions of the contract. The representation, guarantees, covenants, indemnities, guarantees, releases, conditions, right? Event of default and remedies, boilerplates, and the signatures block, exhibits and attachments. So those are the main content of a contract. And here they just give you the heading. Not really the heading, but the gist, right? And you can see that when drafting a contract, first of all, there are different ways to draft and to organize the contract, and you will have a chance to learn how to organize a contract later. But here, you can see that you can organize a contract through the very general provision into the specific ones. But sometimes they continue after the specific ones. You have some general provisions again. And they may organize into like the most important one to the less important ones. Or they will set out some rules, some provisions, and then the exceptions later. And they can organize the contract into a general provisions and then the sub provisions. And yeah, they prefer to, except for the introductory paragraph, they will give you the technical content and then the boilerplates, right? The boilerplate is considered as a housekeeping clauses. right? So now I would like to go into detail. The first one is the title of the contract. So it can be said like, is this a caption? Is this a heading? Like the contract for sale, and for the heading, they can use whatever term like agreements or contract. So it must be consistent. If you choose to use contract, like contract for sale, and then in the whole contract, you must use the word contract instead of agreements. So similarly, like the residential lease agreements, and if you use the word agreement and consistently in the country's agreement instead of contract, right? And for the heading or for the title, people usually capitalize all the letters of the title. I say usually, it means that sometimes people just capitalize the first letter only. So it's subject to them, right? But in order to distinguish it from all the clauses or all the headings in the contract, it could be better for the party to agree on the capitalization of all the letters in the title, right? So here we have the term employment contract or labor contract. Now, the first part of a contract is an introductory paragraph. So in the introductory paragraph, the parties will specify the full legal names of the parties. Legal names here can be the name of an individual or the name of an organization. So if it is the name of an individual, you need to give the full name. Here is the legal name, the name in the identity card, not the name like the people usually call you. It must be like, you may have two names. Both of them are official, and people can use the two names to call you. And even in your family, people will not, like in some situation, people do not know the official name or the legal name of a party. They just know the nickname, right? But anyway, when you enter into the contract, you need to use the name mentioned in your birth certificate, which reflects in your identity card, and you use that name, right? And also, you need to specify some more details on the identity card number, the issue date, and issued by which authorities issue the identity card to you. In terms of an organization, organization can be an enterprise under the law on enterprises, or it can be an organization, it can be an association, so subject to the law on association. So with each type of organization, there may be different details or information about that organization so that you can put in. For example, if it is an enterprise, you need to specify the name of the company, the name of the enterprise. That name is included in the ERC, I mean the Enterprise Registration Certificate. And if you like you draft the contract in English, in the ERC, they require you to note down the Vietnamese name and also the English name. And if the country is in English, and you need to use the official English name of that company. Then each company has their enterprise number, their issue date as well, and issued by. I mean, it also has the name of the authorities who issued the ERC. Even though it is some companies are established in a city, but it's subject to where the company is located. The ERC may be issued by different by different authorities. For example, if it is in the industrial zone, the ERC will be issued by the management committee of the industrial zone. But if it is outside the industrial zone, the Department of Planning and Investments will issue the ERC, right? And you need to note that the legal names. What I want to emphasize here is the name of the companies, the name of an enterprise, which is recorded or registered to the authorities, right? And especially the English name. So some people just use the Vietnamese name and then automatically translate it into English and put it in the contract. They may be incorrect, right? Because they have, like, each company has its own legal English name, and the legal English name may be a little bit different from the Vietnamese one, but it is acceptable as a translation. And then the authorities agree for you to register the English name and the Vietnamese name. So when you put the name in the contract, and you should look at the ERC of a company very carefully, right? Just to make sure you reflect the correct English name. The first and the second information in the industrial paragraph is about the types of transaction. And they refer to, like, on this day, the parties A, B enter into the contract for sale of fruits. So in this case, we know, yeah, it's the transaction is the kind of commercial transaction for sale of something. Then you also put that types of transaction into the introduction paragraph. And define terms used to name the parties. And if you look at the example on page 33, and you can see here they define the name of party A, and they give the name of party A. They can define them as party A, or they can define as buyer, or they can define as seller, right? The transferee, lessee. So those are the terms defined in advance to name the parties. So through the whole contract, it doesn't take a lot of time for the parties just to specify again a very full name of a party, right? They just use an abbreviation by giving a definition to the name of a party, and that's defined usually in the introductory paragraph. Right, the next one is the reference date of the contract. When the contract is entered into will be specified here in the introductory paragraph. And sometimes people read that the date of the contract is also the effective date of the contract. You may question, like in some cases, the contract is entered into by different parties, for example, by 4 parties. And 4 parties are from 4 different countries. So what should be the date of the contract? And what should be the effective date of the contract? So actually, the party can agree on the effective date at any time. And the effective date may be before the date of the contract or after the date of the contract. It's not a big issue, right? The issue here is the date of the contract. When? The date the first party signed the contract, or the date the last party signed the contract, because they are from different countries, right? And you need to circulate the contract for them to sign, or they can sign in form of a counterpart. But what date? So it's subject to the agreement between the party on the date of the contract. Maybe the date of the contract is the one which is totally different from the date the first party signed or the date of the last party signed. It's just because the parties will agree on the date. Any questions? If you have any questions, just text me. Any questions? So if you don't have any questions, we come to the next section, which is the recital. So the recital here contains which information? So usually this recital starts with the word whereas, right? So the recital will give the premises, the basis, the grounds, or providing the information about the transactions or documents. So based on which the contract is made. Now, for example, the 2 parties enter into the contract for sale of goods. You can say, whereas party A wants to sell the goods, and whereas party B wants to buy the goods in order to do the charity job. So this is a recital. So it gives the premises, like the reasons why the party enter into the contract, or you can give the information about the other transaction, just like whereas the parties enter into the master service agreement. According to that agreement, the parties will enter into a service management contract for a specific business. Whereas party A wants to use the service of party B, right? This is a recital, right? The recital here means that previously the parties has already entered into the master service management agreement. And now to detailize or to specify the master agreement, the parties enter into a specific contracts, right? So when you look at the specific contract, you know that, the parties has another contract relevant to this one, relevant to this transaction, which is the master service agreement contract, right? So just look at the recital and you know other transactions relating to the transaction or the contract that you're gonna enter into. They may refer to other documents, just like according to the decision, according to the law, and now today the parties enter into the contract. Yeah. So based on the transaction, based on the premises, or based on the documents, the contract is made. In the recital, there may be some, sometimes people may can explain the purpose of the contract. So the parties enter into the contract for what, right? This is for the purpose. And sometimes the costs can be based on the recital based on evidence. Based on that, the court will know the relationship, the roles of the parties, the nature of the transaction, and any other documents or things related to the transaction are associated to the transaction. Because when you look at the section recital, you know the whole story where the contract is relevant to. Right? So when you do the due diligence for your client to buy a company, they may give you a lot of contracts. And this is my experience when I read a contract. I love to read the various section, that means the recital section first. And I will know a lot of information about that contract and other transaction relevant to that contract as well. And then if the other party failed to give me such kinds of contract, I will ask them, look at the section about the recital. I will know which contracts I'm mixing, and then ask the other party to give us more, right? So that's why here they said the court will base on the recital in order to give the judgments, because a lot of information about the transaction can be seen through the recital. Any questions? Yeah. The next one is the statements of consideration and agreements. Now you can look at page 35 and 36. And you can see the paragraph saying like, now therefore, or in consideration of. So these statements used to like refer to the agreement between the party. Now they have reached an agreement, and then they will enter into the contract. These statements, of course, happen right before the main content of a contract. Is it clear to you? A very simple one, in order to draft a statement of consideration and agreement, is that you can look at the last example. Accordingly, the parties agree. And in my case, I usually say, now, therefore, the parties agree on entering into the contract with the terms and conditions as follows. That's all. Very simple. Question? Now, the next section of a contract is definitions. You have a lesson about how to draft a definition. So I will not go into detail. Just want to inform you that in Vietnam, when we draft a contract in Vietnamese, we rarely use the section of definition. So that can make the contract to be long, because they need to repeat a word which is very long. And then we just repeat that many times in the contract, so it's not good at all. Or if people want to make it clear, even a general term, or they want to narrow down the meaning of a general term, and then they can use the definition section. So when you read the contract, please read the section, the definition section, very, very carefully. Don't think that because it is just give the definition, so you should look at the main content of the contract only. No, this is incorrect, right? The definition may give you a lot of information that in the content of the contract, it just refers to the definition only. Yeah, substantive provisions. So those are the provisions on the terms and conditions of the contract. So there are different ways to arrange substantive provisions. And as I said before, it based on the based on the importance of a contract in order to arrange the substantive provisions. It's like they put the conditions first, and then the rep and guarantees, or sometimes they put the rep and guarantee first, and then the conditions later. Condition. So you know that in the contract we have the conditions, guarantees, representation guarantees. Yeah. Housekeeping provisions is also referred to as a boilerplate, and housekeeping provisions is also considered as one part of the substantive clause. But I think they can put it separately just to make it clear that I think you all know about the boilerplate, right? The boilerplate process. which means that those clauses will appear almost every contract in order to ensure the rights and obligation of the two parties. You don't need to think a lot, but they are very important. So when you negotiate the contract, besides negotiating the main content of the contract, you also agree on the boilerplates. Yeah. Now, the first one, I don't think you have time to read that. I would like to give you 5 minutes to go through the housekeeping provisions, all the housekeeping provisions here. Yeah, with this section, I expect you to give me the answer, but because of the technical problems, so I will explain to you. And if you have any questions, just feel free to stop me and ask me. About the first one, severability clause, which usually state that, so if there is any clause in the contract is found void and the other clauses are still take effect, it means that the clauses in the contract are separate, right? And the choice of law, usually happen in a international contract, which means that the contract is entering to at least between two parties from two different countries. And this is an issue for the party to choose what law will govern their contract. But if the contract is entering to between the parties in the same country, there could not be an issue on the choice of law. And about modification, which means that the amendment of a contract. So it is implied by law that if the contract is made in this form, and then the modification is also made in the same form. I mean that if the contract is an oral contract, then when people want to amend that contract, they can amend it orally. But if it is a written contract, a written and notarized contract, then when you want to modify it, when you want to amend it, it must be in the same form, which means in the written and notarized form. Yeah, no waiver. So if a party has an obligation, and of course in a contract, one party will have an obligation, then the other party may waive their right over that obligation. Now, for example, you enter into a loan agreement, and under the contract, of course, you need to repay the loan to the lender. Then the lender may waive, which means that the lender may say, yeah, I don't want you to, you owe me 1 billion, but just repay me half, which means 500 million only. For others, I will waive, which means that they waive the repayment of half of the loan. It's okay. At any time, a party has a right, can waive the right. But no waiver clause means that they agree on the fact that in case the lender waives the repayment of 500 million, right? It doesn't mean that the lender waives every obligations in the contract. Like no waiver means that when a party waives one clause, one provision, one obligation in the contract, it doesn't mean that that party waives the whole contract, or it doesn't mean that that party waives the other clauses in the contract. And the next one, merger clause. So in case of like merger and acquisition of one party, And how about this contract? So they're just afraid that in case of merger, and that the contract will be found void or will be treated unenforceable or something. So they need to put the merger clause into the contract to make sure that even in case of merger, this contract or this clause will be still in effect, right? And then the parties to the contract needs to inform the buyer about the existence of this contract, just to make sure that the contract will continue. And also the other purpose of this contract is that this contract is the final one, the final agreement between the party, and any other agreement between the party before that, they usually call it is a pre-agreement between the party, and I consider is part of the contract. This clause will prevent the party from just quoting or citing what they have agreed in advance to interpret the contract. So everything written in the contract for now, at the time the parties sign the contract, it is considered as full and final agreement between the parties. So the party should not refer to any other agreement. Yeah. The next one is assignments and delegation. So as we studied before, assignment is for the transfer of rights, and delegation is for the transfer of obligations. So the parties may agree on in case of the assignments. If one party wants to assign the rights of this contract to another party, or if one party wants to delegate the obligations under the contract to other party, what should be the procedures, or if that action is allowable or not? Right, usually assignment of a right, there is no issue. Before the delegation of an obligation, it needs to get the consent of the other party. Now, for example, I have a loan of 1 billion Vietnamese dong, and I want to delegate the loan to my friend, which means that my friend needs to repay the loan to the bank instead of myself. Is it okay? Yeah, I need to get the consent of my friend, of course, and I need a contract between me and my friend. And also I need to get the consent from the bank. What if the loan is based on kind of security? I have mortgaged my house for the loan. But when I delegate the obligation to my friend, she doesn't have any property in order to secure for the transaction. So, and of course, I don't think the bank agrees with that, right? And survivability, they usually say like Article 2 or Article 9 survive the termination of the contract, which means that even the contract expires, the survivability clause and other clause provided in the survivability clause still take effect, still alive. Yeah. Now, usually the clause on the dispute settlement, the clause on the confidentiality. Those clauses usually survive the termination of the contract or survive the expiry of the contract. So people usually forget to trap the survivability clause in the contract. But if it's a boilerplate, so you should put it like a checklist. So if you forget anything, just look at the checklist and make sure that we put it in the contract. Notices. This is a clause that one party will send a notice to the other party, and who will receive the notice on what means, like they send by hand, by email, register mail, or any other means of communication between the party is notice, right? The notices are in English or in Vietnamese. You need to agree on that. Yeah, and when it is considered as a notice received by the other party by hand, it is considered as being received at the time of handing over the notice. But if it is a registered mail, at the time the mail comes to the receiver, he signed in order to confirm that he has already received the notice, right? So this is a boilerplate, but it is very important. There could be arguments on the receipt of a notice because it will lead to another issue. For example, they give the notice to terminate a contract, and what if that notice doesn't come to the attention of the other party, and the other party doesn't know anything about the upcoming termination of the contract, and they keep doing the contract, so there could be harm, like a lot of harms to them. Liquidated damages. So I think you have learned a lot about liquidated damages, right? This is an estimated damages by the parties, just in case there's any damage, any loss, then they just based on the liquidated damages in order to compensate, right? And you know the differences between liquidated damages, the damages, compensatory damages, and then also the penalties under Vietnamese law. And you also know that whether liquidated damages are recognized under Vietnamese law or not, right? So how can we draft a clause which is similar to the liquidated damages? Force majeure. So this is very common. There are two criteria of a force majeure clause. This is you need to put down the events of force majeure, the time for cure, and then the way to terminate a contract based on the force majeure. Like we list out the events, and if not, it will be implied by the law. In the law, there are only two criteria that we can base on in order to determine whether an action is a force majeure or not. The first one is that it is an unforeseeable action or event, and the second one is that it is beyond the control of that party. So this is a force majeure. And there will be some other matters if the party want to put it in. So we finished 7 about the housekeeping provisions. Any questions? No question? So those two clauses are totally different. Severability, which means that if there's any clause in the contract is found void, the other party is still take effect, which means that each clause will be separate from the others. And for the survivability clause, after the termination of the contract, the survive clauses or the clauses are still survive, still take effect. So I think it should be in Vietnamese. Severability là hiệu lực từng phần á, tức là một cái điều khoản vô hiệu thì những cái điều khoản khác vẫn có hiệu lực bình thường. Thì nó khác với cái điều khoản về vẫn còn có hiệu lực sau khi mà hợp đồng bị chấm dứt hay là hợp đồng hết hạn. Nếu hợp đồng bị chấm dứt hay hợp đồng bị hết hạn thì những điều khoản, một số cái điều khoản vẫn còn hiệu lực. Thì trong cái điều khoản về vẫn còn có hiệu lực sau khi hợp đồng bị chấm dứt, là chẳng hạn như những cái điều khoản liên quan đến giải quyết tranh chấp, các bên đã chấm dứt hợp đồng rồi, các bên đã chấm dứt hợp đồng và hợp đồng hết hạn nhưng có tranh chấp xảy ra, thì cái điều khoản thỏa thuận về trọng tài chẳng hạn vẫn còn có hiệu lực. Survive là vẫn còn sống còn, vẫn còn có hiệu lực. Please wait a minute. Các bạn biết cái chữ survive có nghĩa là sống sót á. Là dù cái hợp đồng có chấm dứt hay là hết hạn đi chăng nữa thì có một số cái điều khoản trong hợp đồng vẫn còn sống sót, tức là vẫn còn có hiệu lực bình thường. vẫn còn áp dụng bình thường. Người ta dùng cái cấu trúc là survive the termination of the contract or survive the expiry of the contract, là vẫn còn có hiệu lực, vẫn còn được áp dụng khi hợp đồng chấm dứt, là khi hợp đồng hết hạn. Okay. Now, the next one is the signature block. Signature block is the place that the party will sign. So when you draft the contract, of course, you need to have the place for the parties to sign. This is a signature block. And the date of the contract, of course. The date can be put at the beginning, at the introductory paragraph, or the date can be put at the end of the contract. It's subject to how can you arrange. It's not a big issue. Sometimes to be prudent, some party write the date next to the signature block, next to their signature, saying that I signed this on this date. Notarization or certification subject to the nature of the contract. So some contract needs to be notarized, and they put it like the notarization section. There could be another page attached to the contract, entered into or signed by the notary public officer. Then the contract have the appendixes or exhibits or schedules attached to the contract. Yeah. So you just know like all the sections of a contract. So we have other two other contents that we need to know in this lesson. Is about the assembler considerations. Assembler means that we have already we have the same contract in advance. We have the same transaction, and then you learn from that transaction to draft the contract. Because in practice, no people rarely that people draft a contract from the beginning to the end. They usually learn something from the others, and they use that template. They access the template and tailor the template to make it correct to the new transaction. So in practice, whenever any client asks me to draft a contract, or even when the partner asks lawyer to draft the contract, if the company, if the law firm doesn't have the data management, then you may ask your partner, do you have any templates? Do you have any similar contract? Usually the answer is yes. And if they have the similar contract, and then you can draft based on that contract, based on that sample. Or So when just around 3 years ago, I worked for a Korean law firm. They first set up in Vietnam. Then when they asked they asked me to drop a country. Of course, they don't have the templates. And then this is their question to me. Oh, they want to drop a country like this and like that. Do you have any sample? And we have the transaction like this and like that. Do you have any templates? And then I shared with them. So you can see that in when we work in a law firm, it's good that we have something to share, or we have something to learn from the previous transaction. That is the reason why in other careers, you may retire, but in working as a lawyer, in Vietnamese, they usually call gừng càng già càng cay, which means that the more experience you have, and the more successful you are, right? When you have a lot of experiences, and then you can think of the solution very quick, and then you have a lot of documents, samples, precedents that you can base on. Yeah. When people drop a contract, it cannot be in there forever. So that's why in the boilerplate section or housekeeping section, we have the clause of modification, and this is just the kind of repetition on the modification about the amending contracts for you to know more. Like how can people amend it? I have already talked about the modifications. When a country is trapped in this formality, and then the modification or amendment should be in the same formality or in a more secure security, more secured formality. Now, for example, the country is entered into in the oral form, and then when you amend it, you can make it in oral form or written form. So it is recommended that people should enter into the contract in written form. But when you amend a contract, and what should we do? There are different kinds of amendments. They can change the provision by hand, which means that they look at the hard copy of the contract, and if they want to amend anything, they just use a pen and correct directly on the paper, on the hard copies. So if there's only some minor errors, and you can use the change by hand, right? But if it is a lot of changes, you should not do like that. And you can prepare a second document. The second document can be in the form of an addendum or of an appendix. And you can say like addendum number 1 to the contract, blah, blah, or the addendum number 2 or the appendix number 2 to the contract for sales of this number, blah, blah, blah. So those, you prepare a separate second document. Or the more complicated one is drafting a amendment and the restatement agreement, which means that you will abolish the previous one, just restate the previous one and amend any document, any provisions that are incorrect, right? And you just amend and restate, amend the terms that are incorrect, and then restate the terms which are like correct. In a in a separate document and abolish or destroy the previous one. For number 2, you prepare the second document. The original one still exists, still take effect. But for number 3, you amend and restate the document. The original one will be deleted, will be destroyed, right? So those are the contents of our lesson today. Do you have any questions?
Cô ơi, bạn Nga có nhắn đó cô. Với cả em cũng muốn hỏi theo ý giống như bạn Nga là cái survivability là nó chấm dứt là khi cái hợp đồng nó bị vô hiệu, hay là cái chấm dứt khi mà cái hợp đồng nó hết, nó bị chấm dứt cô. Ý là cái điều khoản đó cô, nó sẽ có hiệu lực khi mà hợp đồng bị chấm dứt, hay là nó có hiệu khoản khi hợp đồng bị vô hiệu? Dạ.
Quỳnh Nga hỏi là cái điều khoản này, điều khoản survivability liên quan đến khoản 3 điều 422 Bộ luật dân sự là chấm dứt hợp đồng khi cá nhân pháp nhân kết hợp đồng chết. Cái này là điều khoản chấm dứt là khác. Điều khoản chấm dứt là trong hợp đồng mình sẽ có điều khoản về termination clause. Còn cái điều khoản này á là khi mà ở đây người ta chỉ cho một cái ví dụ thôi là khi hợp đồng bị chấm dứt, cho nên cô nói là vẫn còn tồn tại nếu hợp đồng bị chấm dứt, hoặc là nếu hợp đồng hết hạn thì những điều khoản này vẫn còn tồn tại. Thì cái incapacity or death thì nó chỉ là một trong những cái mà dẫn đến chấm dứt hợp đồng thôi, hoặc là bất kỳ những cái trường hợp nào dẫn đến chấm dứt hợp đồng đi chăng nữa, bất kỳ sự kiện nào mà dẫn đến hợp đồng bị chấm dứt đi chăng nữa, thì cái điều khoản đó vẫn còn tồn tại. Thì ở trong cái survivability clause này người ta sẽ quy định là cái câu chữ nó sẽ như thế này: Article 8, Article 9, Article 10 of this agreement shall survive the termination of the contract or shall survive the expiry of the contract. Nói rõ luôn, điều 8, điều 9, điều 10 trong hợp đồng này vẫn còn tồn tại, vẫn còn có hiệu lực khi hợp đồng bị chấm dứt hoặc khi hợp đồng bị hết hạn. Thì những cái điều khoản đó là những cái điều khoản thông thường là điều khoản gì? Điều khoản về giải quyết tranh chấp, điều khoản về bảo mật. Thì dù có hợp đồng này có chấm dứt đi chăng nữa, anh cũng không được tiết lộ cái sự tồn tại của hợp đồng này hoặc nội dung hợp đồng này cho những bên khác. Nó không phải là điều khoản về chấm dứt hợp đồng nha. Điều khoản về chấm dứt hợp đồng còn có một cái điều khoản khác nữa. Nó sẽ có thỏa thuận riêng về chấm dứt hợp đồng trong trường hợp nào là chấm dứt hợp đồng. Okay. So I think we should stop here for you to study other class and see you on Wednesday. Okay. So thank you, class. So sorry for the technical problem today. I don't know how to fix it yet, but I'm trying.